everyone, and welcome again to Legal Research and Reasoning. Today's discussion is about exhibits. Specifically, we're looking at evidence and its various types, beyond just testimonial evidence, and the use of visual aids. So, why should we use exhibits, and how should we use exhibits? There are actually a lot of important studies that have addressed this issue. Right, so three big takeaways is researchers have found that learning and retention of material are significantly better if the information is communicated visually. Right, so it's one thing to talk about, well, I pulled down North Street and took a left on Wazak Street. That's a lot different than pointing out on a map where you went, how you went there, right? And so that's where we're talking about visually, it definitely comes into play, right? Because we're different types of learners, right? So you have learners that learn via audio, you have learners that have to see it, you have learners that have to read it, and you have learners that have to do it. I'm a learner that is generally a listener, right? So you tell me something, I can do it. But if I have to read it, it all goes past my head until you tell me. So that being said, jurors are the same way, right? They all have different learning styles. But the best way to communicate is visually, as well as obviously via testimony. Now, that being said, research has also suggested that basic facts repeated 3 to 4 times significantly improves retention. So what does this mean? This means that, and this is true in everyday life, if you hear something said 3 or 4 times, you are statistically significantly more likely to remember it than if you only heard it once. That's why if you have something for a course that you need to remember, I always say it out loud to yourself 3 or 4 times. Because if you do, you will remember it. And again, this is just kind of coming back from basic studies. So that being said, if we can get a witness on the stand, right, and they give us testimony, that's one time. If we then can show them an exhibit, that's the second time. If they talk about the exhibit or point to the exhibit or we confirm their testimony, that's a third time, right? So this is where exhibits come in, but very important. In addition, information is communicated to the jury through what we call multiple channels, right? So this is the different styles of learning, right? So orally, written, and visually. And the more channels that we can use, the more likely we will have a significant retention of the key points, right? So if you tell a juror, like they hear testimony that they saw the gun on the counter, and then you see a written deposition that says, yes, the gun is on the counter, and then you show them a picture of the gun on the counter, guess what they're going to remember? The gun was on the counter. They might forget everything else, but that's what they're going to remember. So you want to be strategic about this, because the human brain only has so much memory, short-term memory, before we just start forgetting things because we don't care. So you should use this 3 to 4 in visual aid issue or methods whenever you have a major point to make, right? Something that the jury needs to understand, something that the jury needs in order to find in favor of your client, right? So that's where exhibits come into play. This is kind of the social science regarding exhibits. So what exactly is an exhibit? So there are 8 common types of exhibits. Each are governed by a rule of evidence or rules of evidence. And we'll go through these fairly quickly because, again, you should have a general idea what these are, right? So we look at Federal Rule of Evidence 901. It deals with objects, right? So an object is literally an object. It is something that's tangible, right? It's when we think of like real evidence, that's what objects are. So think of an exhibit would be the gun or the knife that was used. That's an exhibit, right? Demonstrative evidence, 901. It's in a weird realm of sort of being an exhibit, but at the same time not being an exhibit. Because generally speaking, to be demonstrative, it has to meet certain criteria that we'll go through here in a little bit in terms of visual aids. But it in itself doesn't necessarily have any evidentiary value. That being said, when I'm talking about demonstrative evidence, there's a really cool case, and I can send you the name here in a little bit. It was a lawyer who was defending somebody in a murder trial. And he had, and the murder was conducted with a gun. And his theory of the case was the person had committed suicide, and like, this is how you could do it. And so he demonstrated to the jury how you could like take the weapon and put it where you put it and pull the trigger, right, and have the weapon land where it lands. Only problem is he didn't realize the gun was still loaded. So when he takes the gun to his chin, pulls the trigger, he kills himself. That being said, the jury then acquits the defendant, right? So he killed himself and then won the case. Because they're like, oh yeah, I guess you can kill yourself that way. Like, we try to stay away from that, right? Generally speaking, evidence is usually protected. We don't like to take it out of bags or things like that, unless we absolutely have to. We also have writings and instruments. So this is 901. We have business records, which is 803 sub 6. Public records, 803 sub 8. Summaries, which again, this is going to be more of a visual aid. Recorded recollection, which is rule 803 sub 5. And this is anything that will help jog the memory of the person who has forgotten information. The opposing party can move to have that thing put into evidence, right? So it can be an exhibit. And then testimony or transcripts of testimony. So this is 801, 804. You run into some hearsay issues, but generally speaking, if it was like a deposition, that's testimony, it's under oath, there's a chance for cross-examination, then you're probably going to be okay. So let's look at exhibits in the broad sense, right? So Federal Rule of Evidence 611 sub A provides that, and here's the quote, the judge shall, quote, control the mode and order of presenting evidence. So it doesn't get really that specific. It basically is like, hey, judges, you get to control mode and order of presenting evidence. The fact that the prosecution goes first, the defendant goes second, that sort of thing. Theoretically, that's up to the judge, but I mean, they all do the same thing. That being said, that's our broad rule. As we get more specific, right, and we look at local rules, so courts will have local rules that only apply to that court. And we look at case law, right? There are, and have been articulated, specific procedures for introducing exhibits. And we'll go through how you introduce the exhibit in a minute. That being said, regardless of the rules, your role And introducing an exhibit should be to, one, create a clear record, right? So make sure there's no confusion or anything like that among the jurors. Two, establish proper foundation for each exhibit. And what foundation is basically the reason it exists, why it's important, why we need to know about it, the chain of custody, etc. And then three, give the opposing party a fair chance to challenge the admissibility of the evidence. All right, then we'll talk about being able to avoid somebody about an exhibit and challenge the exhibit and what you do if somebody objects. So how do our general procedures work? They work in this following sense, right? So the very first thing you're going to do is you are going to have the exhibit, the thing that you're going to offer into evidence, marked, right? If it's not already marked. So generally speaking, there's little stickers we have. One says plaintiff, one says prosecution, and one says defense. And it's a little sticker, and you put it somewhere where it's not covering anything, and you write a number. If you're on the other side, you write a letter. And the idea here is that you already have it pre-marked. Now, it doesn't mean it's in evidence, but you can refer to it, right? So you can show the exhibit and say, Your Honor, please let the record reflect I'm showing what's been previously marked as defendant exhibit 7 to the prosecution, right? Now, you don't have to go in order. So it's easier if you do, and you don't have to introduce everything into evidence, but you're going to want to have anything that could possibly come into evidence pre-marked, right? So next thing you're going to do is, generally speaking, you have to ask the judge, but you're going to show the exhibit to the opposing lawyer. So you say, Your Honor, may I approach opposing counsel and the witness in turn? And they'll always say yes. Right, so you show it to the lawyer, they get to look at it, they get sufficient time to look at it, and then they give it back to you, or you might just have a copy for them. Then you ask permission to show the exhibit to the witness. All right, so Your Honor, may I approach the witness? Yes. You give the witness the exhibit, and when you give the witness the exhibit, you would say, Your Honor, please let the record reflect that I've just handed defense exhibit 7 to the witness, right? And you're just, remember, you're creating that clear record. So from there, you question them about the document, but you're not talking about the specifics of the document or the specifics of the object or anything like that. What you're doing is you're establishing the foundation for the exhibit, right? And the foundation is, all right, what is this exhibit? How do you know what it is? Are you familiar with it, right? And the idea is we want to make sure that what we're introducing is authentic and real. So let's say that you want to bring in a gun, right? An object is an exhibit. You begin with, Mr. Jones, I'm handing you, it's been marked as defendant exhibit 7. Can you identify for the court what this is? Like, it's a gun. And you might have to ask a follow-up question of something along the lines of, are you familiar with this gun? Yes, it's the gun that was used by my co-conspirator in the commission of the crime. Well, how do you know it's that gun? Well, I know it's that gun because the exact same make, model, and has this scratch the other one had, right? And they go into detail. And so the idea is you're establishing very well, almost over-establishing why this exhibit, this evidence should come into play, why it's proper, right? Only after you have established a foundation can you offer an exhibit into evidence, right? And so what you do is you basically turn to the judge, say, Your Honor, we offer defendant's exhibit number 7 into evidence, or defense number 8 into evidence. right? Um, and what happens is it'll get remarked by the court clerk as like the number sequentially that you've offered it. So it'll change to like defendants 1 or defendants 2. Then and only then have the witness use or mark the exhibit if it's proper, right? So if there's no objections, and there will usually be an objection to a lack of foundation, and if you've successfully laid a foundation, you should be good. If not, it doesn't mean they can't come into evidence. It just means you have to ask some more questions to make sure it's authentic, genuine, and relevant. So if we're talking about something that we are going to read to the jury, right? We have it marked. We can do enlargements of like maps. So we can have a witness come down off the stand and point to a map, like, where were you? Where was this? Where was that? And make marks on the exhibit if we want to, but it's a blow up. And we'll talk about visual aids in a minute. But again, you have the witness use or mark the exhibit, and then you ask permission to show or read the exhibit to the jurors, right? And so what you're going to do, and this is it's called publishing to the jury. What you're really going to do is your book says one thing and reality says another. Your book says you give it to the first juror, the juror reads it, and that person gives it to the second juror, that juror reads it, and it goes all the way down the line, right? And then when it's done, you read the exhibit to the jurors, right? So that's the second time that they hear about it. You show it to them and you read it. And you read it with the inflection that benefits your side. Now, when you show or read the exhibit to the jurors, this is called publishing to the jury. If we have something that doesn't, if it needs to be read, we need to read it, right? So we can put inflection, we can do little tricks here and there. But if it's something like a gun, right, which is in the evidence bag, all that jazz, my recommendation is you do not ask the judge to publish the exhibit to the jury until you are ready to sit down, right? Because as soon as you publish the exhibit, you hand the exhibit to the jurors. So what are the jurors going to be doing when the other party is doing cross-examination? They're going to be looking at the gun. They're not going to pay that much attention to the cross-examination, right? It's natural human instinct. Like, I can either look at a cool gun or I can listen to some person probably lie. That's cynical, but I mean, it kind of is what it is. It's a little bit of a dirty trick, but it's not wrong by any means, and you don't get punished for it. And the same is true on cross-examination. So if you offer something into evidence on cross, you publish to the jury right before you sit down. So again, they're not listening to any redirect or a new direct examination. So let's say you have an exhibit, right, and you offer the exhibit into evidence, and opposing counsel objects to it being offered into evidence. Opposing counsel wants to make arguments as to why it should not be in evidence. Or the judge wants to hear arguments about the exhibit and what should or shouldn't be in evidence. Whatever you do this at sidebar, right? So remember, we talked about sidebar is where you and you as counsel and the judge with the stenographer and court clerk sitting right there kind of whisper back and forth your arguments, right? And so the idea is the court clerk and the stenographer, they get down the information, right? They take down everything that's said, but the jury cannot hear it, right? That's the whole point. It's like you talk quietly so the jury can't hear it. And you want to do this because if it's your exhibit and the person's like, oh, well, this happened, and then this happened, and this happened, and like, it makes your exhibit look unreliable or bad, you don't want that. Now, that being said, if you have a serious objection to an exhibit, or you think you can destroy the foundation for the exhibit, as opposing counsel, right? So if there, somebody offers this as an exhibit and you object, you may ask the judge, and you have the right to voir dire the witness regarding its foundation, right? So when talking about voir dire the witness, you can ask the witness questions to further develop their testimony about the relevancy, the reliability, whatever it is, of the thing coming into, that's being offered into evidence. And if you're good at it, you can destroy the foundation, right? You might have somebody say, well, I actually heard, well, the police told me right before I came in that this is the gun that was used. Well, that doesn't come out on direct, but you can voir dire the witness and get that to come out. And as soon as that comes out, then we have a really big issue, right? Is this relevant? Is it reliable, et cetera? So you can always voir dire the witness regarding the foundation of an exhibit. Now, just like testimony, and we've discussed this in extreme detail, exhibits have to meet 3 criteria. They have to be relevant, right? So they have to make some fact and controversy either more or less likely, even just by just a hair is fine. It has to be reliable, and that's one that gets people in trouble a lot, because certain exhibits lend themselves to not necessarily being reliable, that lend themselves to being changed, altered, etc. And you have to show that the exhibit is right? That it stands for what it is being offered for. Now, I encourage you to be careful about hearsay exhibits, right? So hearsay, if you recall, is an out-of-court statement made inside of court, or used inside of court to prove the truth of the matter asserted. So things like, and they usually come into evidence, but like, think about the person, a witness writes a letter to another witness. That's not a court statement. And we use it in court? Generally, no, unless an exception applies, right? And we've gone through the exceptions in pretty exhaustive detail. Now, that being said, even though they are technically hearsay, some commonly admitted hearsay exhibits include contracts, right? So you can see the contract that the person is accused of breaking, promissory notes, I promise to pay you back, checks. So if you're like check kiting, we can bring in the check and say, look, yeah, it was made out of court and it has a statement, and we're using it against its a party opponent, so we can use it. And also notice letters, right? Notice of non-compliance, notice of ending employment, that sort of thing. So, objections to exhibits. So let's say an exhibit is relevant and it's reliable, right? We've established that through our foundation. It may not necessarily be what's called right, right? So something is not right if the probative value is substantially outweighed by a danger of one of 3 factors: unfair prejudice, confusion of the jury, misleading the jury. Right, so probative value is basically, what does this exhibit tell us? What information is it giving us, or that we need in order to make a decision whether somebody is guilty or not guilty? Okay? The most probably debated one that's going to come into play will be probative value is outweighed because of unfair prejudice, right? So let's say that you have crime scene photos, and let's say it's a murder of a child. You have crime scene photos. Now, those crime scene photos are probative, right? They allow you to show what happened, show all that jazz, right? Show where the murder occurred, show like how, show if there's a blood trail, that sort of thing, which the jury needs to know. That's probative. However, if I am a lawyer, I'm going to find the most gruesome picture I can of that child, and I'm going to have that sucker blown up to a poster size. And then I'm going to put that bloody picture of a child in front of the jury, right? That's what I want to do. Will it happen? No, because the other side will object to unfair prejudice, right? And unfair prejudice is basically the jury's making their decision based upon emotion that relies on this object, as opposed to factual evidence. Now, think about me blowing up a picture of a dead kid versus me blowing up a picture of a map. Right? One would create unfair prejudice. The map probably wouldn't, right? And it might even be useful for both sides. So you can point to like streets, or you can point to houses, whatever you need to do. We also run the risk of danger of confusing the issues, right? Basically telling the jury like, oh, this is really what we're fighting about, when we're not. Or it can mislead the jury, right? So let's say that I have a picture of a child who's been murdered but is in a casket, and the casket lid is open. As a defense attorney, I might want to bring that in. So you can be like, look, it doesn't look like he got struck in the head, because what funeral homes do is they have all kinds of techniques to like restore and repair damage. And that would mislead the jury, right? Because no, realistically, funeral homes, they fix up the person, etc. So you can't show me the kid in the casket and say he wasn't bludgeoned to death, but you can show me the bloody pictures as long as you don't blow them up, that sort of thing. So that's when things are right? And so it's kind of this weird balancing test that you walk. And in order for something to come into evidence, it has to be more probative than it is prejudicial, right? Or confusing or misleading. Now, keep in mind that the rest of the federal rules of evidence still have to be satisfied when it comes to exhibits. So generally speaking, it cannot be evidence of a character trait. That's Federal Rule of Evidence 404 to 405. Generally speaking, it can't be under the other acts rule, which is Federal Rule of Evidence 404 sub B. It has to abide by the sexual assault rules, Federal Rule of Evidence 412 to 415. I don't know if we talked about this. We talked about the other things, but I don't know if we've talked about this in depth. So I'll just give you a high-level overview. When we're talking about sexual assault, before we had these rules about sexual assault, I, as the defense attorney, could have the victim on the stand, and I would walk through her sex life. And I'd ask her about any kinks she was into, any tie-ups, do you have a rape fantasy, whatever. So really re-traumatizing this person. And it's a really dirty, horrible trick. And so what happened is the courts and Congress stepped in and said, no. Sexual assaults, you can only ask questions about a person's sexual history if you can prove that it is extremely relevant to the case, or at least at bare minimum relevant. You can't just ask them about it just to ask them about it, right? Generally speaking, the court has to approve of your question before you can ask your question. So if there's something on the exhibit that shows how many sexual partners that the victim in the case has had, then it's probably going to violate the federal rules of evidence. Even if it's probative and it doesn't create unfair prejudice, it still would violate the sexual assault rules. Right, so keep in mind, we have rules that dictate exhibits, but we also have to abide by every single other rule in order for that exhibit to be right and to be received. So talk about something a little different, visual aids. So generally speaking, visual aids are not considered evidence. They merely make visual what lawyers and witnesses say during a trial. As such, visual aids do not have any formal governing rules like exhibits do, right? The rules governing exhibits do not apply. So what are we talking about? We're talking about visual aids. It kind of depends on the stage of the trial, but we generally incorporate a lot of visual aids during opening statements, right? And then, so we're talking about the relationship between corporate parties and employees, right? Showing like a corporate map. Maybe we have a chronology of the events. We want to show the jury like this is how the events played out. Anything along those lines that's going to help orient the jury, right? So a visual aid is not considered evidence. It is not considered evidence. It is merely there to help the jury understand. Now, if we're in closing arguments, I might have charts or diagrams of damages. Like, so if it's a civil case, I might show like, this is how much the vehicle was worth before, and this is how much the vehicle is worth now, etc. I might have a bullet point list of my arguments, right? So I might say, ladies and gentlemen of the jury, I have 3 arguments as to why you should acquit Mr. Jones. Number 1, and you have it listed out in bold format for them to read, and it's staring at them the whole time. It's a visual aid, right? So the rules of evidence don't apply. You also might have the level of elements and defenses. So basically, if you're talking crime, like if your person is being charged with murder 1, but the jury can always come down with like manslaughter. But charged with murder 1, you show like murder 1 has to meet these elements. And let me show you how it didn't meet these elements. But manslaughter does meet these elements. And let me show you how it does meet these elements. Right, so that's kind of how that all plays out. Now, you can use general aids, your visual aids, so long as the lawyer can, 1, properly say it in court. The lawyer can show it through a visual aid. Right? So if it's something that might get objected to or that you can't say, then it cannot be in a visual aid. But if it's something that the lawyer can properly say, you can use it in a visual aid. Now, visual aids are also common when we have expert witnesses, right? And we'll have a whole day when we talk about expert witnesses. They're basically there to explain complicated processes to generally uneducated jurors, right? Especially jurors who aren't in the field. So we might have an expert witness, and he might start talking about, well, at first the 397 press begins by creating a template for, and you're just like, the jury's glazed over, right? I'd be glazed over. But if I have a chart showing me all the steps to the manufacturing process and where the issue is coming into play, then that's different, right? Like I get to interact with something, I get to see something. You get to point out to me the different steps. An accounting analysis, like I'll blow up somebody's financial records. One that's really helpful, especially in medical malpractice suits, are steps in a surgical procedure. Right? So you have a doctor on the stand as an expert witness, testifying basically against another doctor, and you say, all right, so let's say that you are operating on a hernia. Step 1, how do you do this? And they walk you through the steps. You might get glazed over, but if you have a chart, that witness can get up from the stand and point to each step, or you can point to each step, right? And say, okay, so first you do this, and then second you do this, you do this, you do this, then you do this, right? And then in closing, you can bring that chart back out and say, this is, you heard from a doctor, this is how you do a hernia operation. And then you heard from the defendant that they did not do the hernia operation in this order. So therefore they are liable, right? So you can always bring back visual aids. They're not just a one and done, but keep in mind, you have to keep them separate and apart in your mind from exhibits, right? Exhibits are evidence, visual aids are not evidence. So next class, we are going to talk about the expert witnesses. That being said, I do not have time to show the video I want to show you. So what I'm going to do is I'm going to reserve some time from expert witnesses to show you the videos that I want to show you. So that being said, it's a short class today. Don't see any questions, so thank you for joining us. And if you do have questions, please feel free to email me. Have a good day.